Hello and welcome to this webinar entitled Notice Provisions and Breach of Warranty Claims, an Essential Update with me, Keith Marker. As always, let's begin by having a look at the agenda, which is, as usual, very wide-ranging for this session today. So we're going to look at issues around timing, and essentially this is the key consideration with regard to essentially notifying and indeed then issuing and serving in respect of these claims. We're going to see there are various facets to this, but essentially what we're going to begin by looking at is how we calculate the basic time period, typically by reference to the date of completion of the share purchase agreement. And we're going to look at, as I've said, periods of time from that point onto notification and then onto issuing and serving any claim. And we'll look at a variety of case studies with regard to that. Now, there is an alternative in terms of how we calculate the relevant time periods, and that is by reference to the knowledge of the buyer of the particular claim. We'll look at a particular case on that, and we'll see that typically in that particular set of circumstances, we have a shorter period of time, and we'll look at some of the key considerations there. Now, one thing is about the general sort of timing requirement by reference to the completion date or the date of knowledge. However, another really important issue that we'll spend a lot of time on in this session today is the issue of the content of the notice. So how much detail do we need? Do we need to refer to specific warranties and so on? And there's all sorts of scenarios that we will look at by reference to recent case law in terms of that level of detail, and particularly the meaning of phrases like, basis of the claim and reasonable level of detail. What does all that mean? What have I got to do to comply with that in practice? And then finally, just to sort of finish up, we will look at the issue of the manner in which the notice has to be provided. So in terms of it being in writing, what does and doesn't that include? In terms of it being signed, what does that include or not include? What detail do we put in terms of address and also the ability to amend the address? And in particular, finally, the issue of deemed delivery. What sort of provision might we insert? So we'll go through this looking at this particular issue from the perspectives of both the seller of a particular company and the buyer, and we will look at sort of competing considerations as we go. The general rule, though, is this. In terms of notification of breach of warranty claims, the seller wants to make the mechanism as complicated as possible with a view to arguing that the buyer's notice is invalid. Unsurprisingly, if you're looking at this from the buyer's perspective, normally you'd want to simplify this as much as possible to avoid you essentially falling into some grey hole or tripping up over some hurdle that has been placed in your way. But be aware that classically our courts take a fairly strict approach to interpreting the sorts of clauses you're going to look at. So effectively, if it's there, you need to comply with it strictly. They are not going to give you a great deal of grace if you fail to do so.